This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Ballmer, and today I'm excited to welcome Dr. Philip Cross to the show. Dr. Cross is the founder of Kenyon Consulting, LLC, an economic and statistical consulting firm. He has over 20 years of experience as an economist and statistician in academia, government, and consulting. Dr. Cross holds a PhD in economics from the University of Wisconsin. Dr. Cross, thank you so much for joining me here today on Engaging Experts.
Oh, it's my pleasure, Noah. Thank you.
Of course. Let's jump into it. So you're a PhD economist with a background ranging from, academia to consulting. How did you first become involved in expert witnessing?
Okay, so yes, when I first finished my PhD, I went into academia. I taught in the economics department of Georgetown University for a few years. Then I left academia and I entered consulting. And when I first entered the consulting world, I was already living in Washington, D.C., because I had been working at Georgetown. And there's a number of big consulting shops on K Street on Pennsylvania Avenue in downtown D.C. And I ended up working at one or two of those for the next few years, including Deloitte. There's another mob called Berkeley Research Group, and then there's another mob called Alex Partners. And after doing it for a few years, I basically decided to go out and start my own business. So that's what I did 5 years ago. So I've been an expert witness for a while, and I started my business 5 years ago, and it's going gangbusters. So it was the right call to make that move 5 years ago. Yeah.
Tell me about your first call. So you get an engaging attorney randomly calls you out of the blue and says, "Hey, we need an expert in your field." What's that first call like? What are the sorts of questions that you're asked? And now that you've been doing this for a while, what are the sorts of things that newer expert witnesses should know and should also be asking? Because it is a two-way vetting process. They're vetting you as an expert, but you're also vetting them. Is this an engagement I want to take?
Yeah, that's an excellent question, Noah. So my style may or may not be relevant to new experts. Earlier in my career, I got a lot of advice that I tried to follow, which was you've got to be very slick. You've got to be very professional. You've got to tell the potential client what they want to hear. And following that advice didn't really get me anywhere. I'm kind of a take me how you see me sort of person. And if I'm not behaving like that, I just feel like I don't come across as the best version of myself. So I actually ignore all that sort of advice. And when a potential client reaches out to me, I'm just very frank with them. I have experience with a number of different areas of economic consulting. And so sometimes I have the potential to be engaged on a matter that I have a ton of experience in. And so then I'll just say, look, I've got a lot of experience doing this sort of a damages analysis or whatever, or whatever it is, and I'll explain it. And then on other occasions, I'll be kind of chasing a lead where I don't have a ton of experience, but then, perhaps it's the sort of litigation where I kind of think, well, I don't have specific experience for this stuff, but I think there's probably no economic experts out there that have a specific experience in this stuff, so I can throw my hat in the ring along with everybody else, and we can see how I go. And so I've kind of learned over the years. Well, I guess I've kind of unlearned over the years to try to be slick and professional or whatever. I mean, I'm just myself. It's not that I'm completely unprofessional when I'm being myself, right? But it's just I don't put on any bells and whistles to try to impress people. I can actually tell you kind of one or two interesting stories about some gigs that I've gotten, and I was kind of curious as to how I got them. So a few years ago, I got a plaintiff side matter, working with the plaintiffs on a class action in Alabama. And then the next year, that was maybe 2 years ago, I got another one. This one was, I was working on the defense side in litigation in Mississippi. And at that point, I'm like, I don't really think about getting a ton of business from the deep South. And so I thought, oh, this is curious. I ended up with this, this one gig from Alabama and this other gig from Mississippi. And I was talking to a friend of mine, and this friend of mine said, Phil, I think I know what it is. I think a lot of these Southern lawyers, especially lawyers from the Deep South, they're looking for an economic expert. Most of the economic experts I go, these a lot of them are going to be similar to me. They're going to be white guys with PhDs, and they're going to live like in the mid-Atlantic or in the Northeast. That's all like me. But then the way that I'm different is these guys are all going to talk like Yankees, right? And so I don't sound like I'm from the South, but I don't think I sound like I'm a Yankee at all. And my friend has a theory that that's maybe where I got those gigs, and who knows? Maybe that's true.
Sure.
And there are other kind of wrinkles that I can kind of go with. I moved from Australia to the US to go to grad school, and so I lived in Madison, Wisconsin for 5 years while I did my PhD at the University of Wisconsin. So occasionally I get kind of leads for something in the state of Wisconsin. So I'm always going to put my hand up and say, look, I spent 5 years living in Madison. I got my PhD from the University of Wisconsin. If I have to end up testifying in front of a jury in Milwaukee or whatever, I will be speaking with an Australian accent, but I will have that little local connection that I can kind of draw on. So, yeah.
One of the things that you mentioned that was interesting to me is, you get engaged for some very hyper specific niche that there may in fact be no economist that is an expert in that very, very particular thing that they're looking for. How do you go about disclosing to the client, hey, I have the skill set for this. I haven't, I'm not necessarily an expert in it because nobody is. So there might be some research. Tell me about how does a conversation like that go?
Okay, so that's an interesting question. And before I answer that question, I will just confirm that the premise of your question, it's a really good one, because I have had, I also work with some expert search firms like the Roundtable Group. There are some others I work with as well. And these expert search firms sometimes reach out to me, and they have the most ridiculous requests for the sort of expert they're looking for, right? Oh, we want an economist, we want an economic expert who has a PhD in economic and who's very steeped in the solar panel industry in the northern part of the state of Arizona. It's like, okay, well, good luck finding that person, right? So, but sometimes I get these requests come in that are like that. So, to answer your question, it's important for me when I'm retained to work, for example, on a litigation matter, and 98% of my work is litigation, expert witness work in litigation matters. When you're working on a litigation as an economic expert, it's very important that the parameters are set so people know that you're opining as an economic expert and you're not opining about anything else. So, for example, I'm working on some arbitrations at the moment that involve the video game industry, and I've had to develop some knowledge of how that industry works to be able to work on these matters. But I'm not expected to become an expert in the video game industry. And for example, some of the research I did to learn about this stuff was, just Googling and talking to my 12-year-old son who knows he's a gamer and I'm not, right? So that's
Sure.
one way I've learned a little bit about the parameters of the industry. And then on this particular matter I'm talking about with the video game industry, the lawyer I'm working with is good. In that he realizes that I'm not expected to be an expert in the video gaming industry, and I'm expected to be an economic expert. So that's something that it's good to set out from the outset that I'm not an industry expert in whatever the industry is. I'm opining as an economic expert. And then, by the way, another trap that advice for young experts, another pitfall that you don't want to fall into when you're a young expert is if you're giving deposition testimony or if you're writing an expert report, do not offer a legal opinion unless you are in fact a lawyer. But I'm not. Most economic experts have PhDs in economics, but they're not lawyers, and that includes me. So I have to be very, very careful that I'm not offering anything that can be interpreted as a legal opinion, because again, I'm going to be opining about an area outside of my expertise, which is a big no-no. So I'm really cognizant of trying not to do that. I work on matters in a ton of different industries. and I'm not an industry expert in any of them. But I've been doing this for a while. I've been an economic expert for 15 years. And so you occasionally kind of get a lead for a matter where, there's kind of some similarity to some matter you've worked on earlier. And so you just get to tell the potential client about your experience there as well.
Is there some kind of a tacit understanding that you're going to have to do some preliminary foundational research to be able to apply your opinion to these potentially unfamiliar areas, such as, video games? You have to learn a little bit about something just so that you can apply your economic expertise to it. Is that a billable occurrence? How does all of that work?
Yes, it is. It is a billable occurrence. Although a lot of my clients are kind of price sensitive, so they're interested in the approach I'm going to take with a view to keeping the bill down. And by the way, I've been running my own firm, Canyon Consulting, for 5 years ago, and this is a little bit of a niche in the market I had, because before then I was working for these big downtown DC economic consulting shops who are not at all flexible on their billing, right? They bill at top dollar. And that's fine. That's their business model. But now that I've ventured out on my own, I'm kind of chasing after a different market than what, those guys typically capture. And so I pretty much everything I can anticipate doing, I'll tell the client that's going to be billable. And so doing research into a particular industry that I'm working on is going to be billable. It normally doesn't take too long. And, I use whatever resources I have available. As I mentioned before, my 12-year-old son is a good resource sometimes. I also have a couple of fantastic junior staff that work for me on a contract basis. Really smart guys. One's in grad school, one's an undergrad. And these guys are like 22, and I'm in my 50s, and so they just know about certain parts of the US economy that I don't really know about again. So I draw wherever I can on getting on, helping to get on top of stuff like that. To kind of answer your question is yes, to the extent that I anticipate that I'm going to need to do research like this, I do bill for it, but I'm always trying to be upfront with clients about what I anticipate is going to be involved on a particular project and what I anticipate the billings are going to be.
Since we ventured into billing, let's talk for a moment about how you structure your billing. Do you have a non-refundable retainer? Do you have different billing rates depending on what you're doing? Is it just one simple billing rate? Tell me a little about the anatomy of your billing.
Sure. So I don't charge a retainer, and that has come back to bite me on two occasions. I've been in the 5 years I've been running my own business, I've been stiffed twice. Once for $5,000 and once for $9,000. So both of those situations when they occurred were really, really, really annoying. But it's the price of doing business. I'll kind of take it. It's kind of unrealistic to expect that's going to happen 0% of the time. So it has happened twice for me. And so I can live with it. And my response to that is to not insist upon a retainer. I just try to feel out clients to make sure that they're kind of legit. And I try to kind of avoid kind of getting involved with someone who I think is likely to do something like that. So I don't charge a retainer. Okay. As to my bill rates, yes, I have a tiered system. I have a bill rate that I quote for defense work, and I have a bill rate that I quote for plaintiff work. My defense bill rate is higher because clients on the defense side tend to have deeper pockets. And again, let's think back to when I worked for these, big downtown economic consulting shops on K Street or on Pennsylvania Avenue in DC. 95% of their work was defense side work because they've got these defendants with deep pockets who can pay those high rates that those guys charge. So back in those days, I was doing a lot more defense work. These days, I do not zero defense work. I do a mix of defense and plaintiff. Maybe it's 25% defense and 75% plaintiff. That's kind of how it works out for me these days. And by the way, I really like having a mix of plaintiff and defense work, because if I just did purely plaintiff work, there are some economic experts out there who only do plaintiff work, and I don't want to be one of those people, because I think it makes my integrity and my reliability as an expert able to be challenged, when I'm testifying. It's like, oh, you're like a hired gun for the plaintiffs. And I'm like, well, actually, no, I do this type of work for the defense as well. And if I was, I can point you to situations where I've used pretty much the same sort of analysis on the defense side of a particular type of case. And then another time when I did the same thing on the plaintiff side of a particular type of case. So that really protects me from, that sort of those sort of attacks on my integrity. So that was a little bit of an aside. Yeah, but back to my bill structure. I have a higher bill rate that I quote for defense work, and I have a lower one that I quote for plaintiff work. And on top of that, those two rates that I quote, they're kind of my, I can use the term from the hotel industry, they're kind of my rack rates. That's kind of a starting point. But if I think a matter is interesting to work on, and I'd like to get the rate, I'll say, look, my standard rate is X, but this sounds like an interesting case, and if my standard rate causes you guys to balk about hiring me, we can talk about me being flexible in the rate. And I do that. Yeah, I discount off my standard rates more often than I charge my standard rates. So that's that's another part of the flexibility that I have from running my own one-man shop, and it's great. And it's kind of a mix of things. If it's going to be like a big gig, if it's particularly interesting, if it's maybe not a big gig, it's a small gig, but it's the sort of thing where it could lead to further work down the line with this same client or the same law firm. I think about all these things, and I don't have this set formula in my head. It's more of a subconscious thing, but I kind of think, I'll be okay with giving these guys a bit of a discount if I think that's what it needs for me to be retained to work on this particular matter. So yeah.
Are there any travel considerations? You charge a different travel rate?
Yeah, so I don't charge for travel time. So, for example, I flew out to Las Vegas to testify in a trial last month. Yeah, it's now August, so that was in July. So that was last month. I flew out to Vegas to testify in a trial, so I don't charge for the flight. I'm in the DC area. I don't charge for the flight out there, for my time for the flight out there and the flight back. Obviously I am reimbursed for my travel expenses, but I don't charge for travel time. But typically, if I'm flying to Las Vegas to testify in a trial, I'm going to spend at least part of my flight like reviewing my stuff and preparing for my testimony. So that's billable work, right? I'm prepping to give testimony. So yeah.
Sure. Backing up to, you were talking about working for the plaintiff versus working for the defendant. Besides the rates, are there any other fundamental differences as an expert witness working for a plaintiff or working for a defendant in terms of report writing, preparation, anything else?
So a lot of the types of reports that I do involve a damages analysis, and they are quite different between the plaintiff side and the defense side. The plaintiff side, you're typically writing what's called an affirmative report. So the ball's being kicked off to you. You're the first person to possess the ball, to use a sports analogy, right? So there's damages at issue. On the plaintiff side, you write what's called an affirmative report, and you say, I've done this economic analysis, and I think the plaintiff or plaintiffs in this particular matter have been damaged by X dollars. Okay. And then when you're retained on the defense side, you come in as the economic expert on the defense side, and you're typically not doing anything affirmative because the plaintiff's economic expert's report is already out there. So it's your job to rebut that report. So you're not coming up with your own number. It's looking at the number that the other side came up with, and you're looking for kind of credible, reliable reasons to call into question the analysis that they used. So that's a good question. That for an economic expert, plaintiff side work and defense side work, can be quite different.
In structuring those rebuttal reports, is it just a line-by-line situation, or are you whole cloth writing a separate report that just addresses the points that are in the affirmative report?
Yeah, so you do write a separate report, and for example, I could write a rebuttal report to an affirmative plaintiff side report that was 50 pages, and my rebuttal could be like 80 pages. Sure. It could even be more involved, but even if it is an 80-page report, every part of the report is rebutting a particular part of the affirmative report that was produced by the plaintiffs. I'm just trying to think. Have I ever worked on a defense side case where the defense asked me to ignore what the plaintiffs did and just come up with my own economic analysis? I don't think I've ever done that. I'm blanking on thinking of that. I suppose there are certain situations where that might happen. The other thing is the type of jurisdiction that you are working in can affect things as well. I work a lot in federal court and also work a lot in state courts in various states around the US. But I've worked in other venues as well. Like I've worked for the Human Rights Commission of Alberta in Canada, for example. I had one gig there. I've had gigs in Australia that work a little bit different than they do here. So Australia has this interesting thing. I've actually never worked on a case like this in Australia, but as an economic expert, I would love to. Australia has this interesting wrinkle that they sometimes adopt that's called hot tubbing. It's actually not as sexy as it sounds, but it is actually quite interesting. And that's where you have some sort of a trial or some sort of a hearing where the economic experts for both sides turn up at the same time, and they both kind of talk back and forth, and the judge or whoever the person is presiding over the hearing kind of questions both people. And so you kind of both present your testimony at the same time, according to what the judge is interested in hearing about or not interested in hearing about. So I've never been involved in a hot tubbing case, but that would be fun. It's kind of an interesting way to do things. And it's going to involve thinking things through a little bit differently than how I normally do it. So, yeah.
And fascinatingly, they're starting to use hot tubbing in the United States in certain limited circumstances. It's becoming a thing. I actually wrote a couple months ago an article on the topic. Really interesting stuff. Besides that, when you're working in a new venue, what is the preparation like? Do you have to know anything about the laws or anything? Does your attorney have to prep you? Okay, this is the first time we're going into this state, and there's some things you have to know about presenting your case here or writing your report here, or just being prepared for this particular venue. What's it like working in a brand new venue?
Yeah, so I work in brand new venues like all the time. I mean, I'm based in the DC area, so I do stuff in District of Columbia Superior Court a lot, and also like the Eastern District of Virginia and other places close to DC. So there are some jurisdictions I'm in again and again, but there's plenty of others where I'm just kind of one and done. And yes, there are rules in different jurisdictions. I can tell you one that comes up all the time. Prejudgment interest. So if I'm writing an affirmative report where I'm saying some plaintiff has been damaged because of something that happened to them 3 years ago or whatever, jurisdictions let you add prejudgment interest. So if I can say this person has been damaged by $500,000, but that's because of how they were treated 3 years ago, and then you can add prejudgment interest to that to get up to where you are today. And different jurisdictions have different amounts of prejudgment interest. Some jurisdictions, although I've never worked in one of these, but some jurisdictions basically don't allow prejudgment interest considerations at all. So that's a possibility. Lots of jurisdictions have as kind of the standard 6%. So 6% per year prejudgment interest, that's a common one. Some jurisdictions, it depends on the type of law that's being challenged in the particular litigation, so it could be 6% for this sort of challenge conduct, and it could be 10% for some other sort of challenge conduct. And then there's other jurisdictions that say the prejudgment interest should be based on actual interest rates, like the actual prime rate as published by the US Treasury. So that's an example of you need to get on top of how the rules work. I mean, especially for an economic expert, prejudgment interest is like a big thing. You have to get on top of how the rules work in different jurisdictions. Make sure you're doing the prejudgment interest calculation correctly. And then another part of your question was, do the lawyers let you know, kind of guide you along with this? And in my experience, the answer is absolutely not. It's normally me telling the lawyers that, hey, you have to go and figure out what the prejudgment interest rule is in this particular jurisdiction. And you got to come back and tell me what it is, because lawyers that I work with, I mean, I work with some smart ones and some really good ones, but this is just something that they don't think about. I think their kind of base way of thinking is, I'm retaining an economic expert. He's just going to go away and do everything. And that's not quite how it works. It's like, I'm going to have to say, hang on a minute, you've got to help me figure out this. You've got to help me figure out that. And so one of those things is this prejudgment interest issue.
shifting gears a little bit, let's talk about preparation. How do you get ready for the big day, whether or not it's a deposition or if it's going to be some cross-examination? Something's going to happen in court. You have to prepare for it. How do you like to get ready?
Okay, that's a good question. And again, let me talk about lawyers again. So I've worked with a lot of lawyers who I like. A small minority of the lawyers I've worked with I haven't liked, but most of them I like. But I've worked with lawyers that I like who have a completely different approach. Some of them are very, very hands-on and want to kind of hold my hand and walk me through every step of the process leading up to kind of testifying in a deposition, for example. And then I've also worked with lawyers who I hear from them like 5 minutes before the deposition is supposed to start, even though I've sent them like 4 emails in the previous 3 weeks about, hey, are you okay with me doing this? And so, so different lawyers take a different approach. These lawyers that want to take a completely hands-off approach, I'm kind of okay with that because I feel like, I can guide myself in a way that's going to like best serve the clients. So it's really kind of client specific. It's really kind of lawyer specific. And I can even give you a third example of the type of lawyers that I work with. One lawyer I worked with, and the first time I worked with him, he was kind of very hands-on. But then that case went really well, and he was very happy with my testimony and my expert report. And then he was happy with me, so he retained me again, and I worked with him a second time. The second time, he was like completely hands-off. It's kind of like, oh, Phil is now a known quantity, so I'm just going to let Phil go and do his thing. And, so it can work that way too. So, yeah.
Do you have a preference?
I mentioned that there are some lawyers that I kind of don't like working with, and I think that's when the hand holding gets to be to the extent that it's kind of verging into micromanagement. I don't like being micromanaged. I guess my preference, it's kind of Goldilocks, not too far one way, not too far the other way, just a little bit of guidance, but not too much that you're veering into micromanaging me. Yeah.
Do you have any pre-trial or pre-deposition routines? I've had experts tell me they like to drink a lot of coffee, or they like to fast, or they do yoga, or whatever it is that they like to do. Is there anything that gets you in the right headspace?
Okay. So, again, lawyers will give you advice, and the bit of advice I get the most is like the night before trial, don't do anything that varies from your regular routine, So if you normally get 8 hours sleep, try to get 8 hours sleep. If your 8 hours sleep are normally between the hours of 10 p.m. and 6 a.m., try to make it that, blah, 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 blah. And, I have some lawyers that tell me, like, do the same routine. And again, sometimes this is ridiculous advice because, for one, I could be traveling. I remember one thing I was testifying in, because there were a lot of witnesses and a lot of lawyers, to save some money, the law firm actually rented an Airbnb that everyone was staying in, so everyone's not booking hotel rooms. So, that's kind of smart. Although the issue was, this was kind of a pretty crappy Airbnb, and the air conditioning didn't work very well. It's not like it didn't work at all, but I didn't get a regular night's sleep. It was not a regular night for me because I was not at home in my house. My air conditioning works just the way I like it and lets me get 8 hours sleep. So you do what you can. But you end up doing kind of impromptu stuff sometimes. So this kind of stick to a regular routine. Yeah, I guess I don't know if it's like it's kind of a pre-routine. It's like once you get in there and the spotlight's on and you start talking, then I think it's important to kind of stick to a routine. And again, I've been doing this for a while now, so it puts me in a good position, because I know kind of what to expect. There's different types of, in deposition testimony as opposed to in deposition testimony, everyone tends to be much more polite. In a trial situation, or there's other things that aren't trials, but they're called final merits hearings. So they're kind of like trials in that this is the last word that's going to be said on this particular matter. And then the judge or whoever it is, the arbitrator or whoever it is going to make a decision about, which side wins and which side loses. So in these final merits hearings, like trials and these other things can get really, really nasty in a way that they tend to not get in deposition. A bit earlier in my career, I was kind of caught off guard by, because I'd done like 3 depositions that year, but I hadn't done a final merits hearing yet. And I'd come into this final merits hearing, and all of a sudden, people are being really, really nasty to me. caught me off guard a little bit, but again, I'm further along in my career now. I know to kind of expect that. Doesn't happen all the time, but I'm thinking, well, that's one of the things that could happen, because we're in this final merits hearing, like a trial, and under cross-examination, I could, be accused of all sorts of nasty stuff. Sometimes it's everything short of causing the breakup of the Beatles. So.
Speaking of getting impeached on the stand and dealing with some of these very contentious, difficult situations, how do you keep your calm and cool and stay collected during all of this? What sorts of skills should newer experts be developing to be able to take a step back, take a breath, and be able to manage through these situations?
Okay, so the first skill you need to develop is to remember to take a step back and to take a breath. Because if you remember to take a step back and to take a breath, I think 90% of the problems you could potentially run into are going to be avoided. I have given testimony where in the heat of the moment I forgot to take a step back and to take a breath, and like 10 minutes later, the lawyer on my side asked for a 5-minute recess, and then he said, "Hey, Phil, you've forgotten to take a step back and take a breath." And I stopped and thought about it, and I thought, oh yeah, I guess I did. Sorry about that. I'll try to do better moving forward. Yeah. So taking a step back and taking a breath is really important. And then sometimes you get kind of conflicting advice as well. This doesn't happen very often, but it does happen sometimes. It's like, Phil, take a step back, take a breath, speak slowly, speak deliberately. But by the way, you've got to be done with your cross-examination by the end of the day. I'm like, well, it's like, if you want me to go fast, you want me to go slow. You're like telling me two things at once, right? So there's stuff like that can happen too.
Sure. Early in our discussion, you had mentioned Roundtable Group. How has it been working with expert witness referral services? Has that been something that's been valuable in your expert witness career?
It's been of some value, and I like having the Roundtable Group reach out to me from time to time with potential cases, and they're not the only type of expert search firm that I work with. There's a couple of others that I work with too. I get business through that route, but I've got to be frank with you. I get a minority of my business through those routes. The majority of it kind of comes straight from my own kind of direct marketing. I've got a website that isn't particularly slick, but I think it's informative. I think people that are potential clients of mine can go there and they can kind of see the type of expert I am pretty quickly, and decide if they want to work with me. And so I have other kind of marketing strategies that I adopt that I think help as well. I mean, again, I've been running my own firm for about 5 years. One of the mistakes I made in the first couple of years was to not spend enough on marketing, because marketing, especially if you come from a long history of working for somebody else and you get paid a salary and you don't have to worry about all this other kind of high-end business decisions. Marketing's kind of a tough one. There's this saying, which I think is absolutely true. 50% of your marketing budget is well spent, and 50% of it, you may as well just flush it down the toilet. But the problem is you don't know which 50% is which 50%. And that's exactly right. And so I think when I first started my business 5 years ago, I wanted a kind of complete confirmation that spending, $1,000 on this or $2,000 on that was going to give me some bang for my buck. And as a result of thinking that way, I just didn't spend enough on marketing, because you never, in my experience, you're just never going to know if you're going to get bang for your buck. You just got to roll the dice. And part of it is kind of just rolling the dice and seeing what happens. So I think I've learned to keep my marketing budget a bit higher now. I think I'd say every year now it's probably between $5,000 and $10,000. It varies from year to year, but sure. Yeah, I think most years it wouldn't be below 5,000, and also not above 10,000 would be my marketing budget. Yeah.
Let's talk about the general a little bit. How do you get off on the right foot in a new engagement? How do you know it's going to be a good engagement? What should the expert be doing, and what should the attorney be doing to ensure that it's going to be effective and efficient and maybe even a little bit of fun?
Yeah. So I'll refer back to an earlier answer I gave, that there are lots of lawyers I work with I like, but they can have very contrasting styles. So if I'm working with a new lawyer, it's really important to me to try to figure out, to the extent that I can, what sort of a style this lawyer is. Is he more of a hands-on, wants to walk me through everything sort of lawyer, or is he more of a hands-off one? Because both styles can work very, very well. but I try to get up to speed with the type of lawyer that I'm working with sooner rather than later. And then the other thing is I often work on cases where I'm not the only expert. There can be other experts as well. And so in that case, it's really important for me to kind of get an understanding of the role of the different experts in this particular engagement, because I really don't want to vary outside of my lane and be stepping on the toes of of somebody else. So that's important to try to get a handle on too. And then other things are important. I talked a little bit about this before as well. It's like because I run my own one-man shop, and I'm not really competing with these big downtown DC shops that charge top dollar. I mean, I really do attract a client base that's somewhat price sensitive, and so I'm just very cognizant of that. And so I just try to make sure that the client is on the same page as me as to the next bills. I'm going to give you a bill at the end of the month, just so you know this is what you should be expecting as kind of the bill to be. And then oftentimes I'll give an estimate for how much it'll cost to prepare an expert report. And then there's a wrench in the works, and things change a little bit. And at that point, I'll say to the client, look, I think I wasn't anticipating this, but it's come up. I really think it's beneficial if I go and do this other little bit of work that wasn't in the original scope of my work. But I just wanted to give you a heads up, because it is going to change what I think the total billings are going to be. And sometimes I'll say, "Yep, Phil, we're fine with that." And sometimes I say, "Actually, Phil, no, we really need you to try to stick to what you told us you think you're going to be billing us." So again, you've got to be respective of the client's wishes in that dimension as well.
That's interesting. You speak about the client. Do you often interface directly with the client without the attorney present, or is the attorney typically present? Or when you say client, do you actually mean the engaging attorney?
Okay, so that's a good question. When I say client, I typically am referring to the engaging attorney. Most of the time, I just deal with the attorneys. I occasionally deal with the client as well. I've told you some attorneys that I work with, I kind of don't like their style. One of the styles I don't like is someone who pulls the actual client in and kind of gives them almost a seat at the table. That's makes it hard for me to do my job as a reliable expert and someone who can opine about things with integrity. So I mean, there can be from time to time the need to kind of learn something from the client. And if it's easier for me to talk not directly to the client, to have a conference call with the client and the lawyer and myself, if that's the best way to figure out what I need to know, that's fine. But I think most of the time, I can say to the lawyer, look, I need to know this about the client, and then the lawyer can go to the client. And so my preferred situation is one where I never directly even meet the end client at all. That doesn't happen all the time, but it probably happens most of the time. And if it doesn't happen, I just don't want things getting to the point where the lawyer is just involving the client kind of too much, which I think, does happen from time to time, unfortunately.
Do you have any tentpole cases that you can talk about? Obviously, you might not be able to give any of the specific names or whatever, but that either change something about the way you go about expert witnessing or reinforce something that you were already doing. What are the important moments as an expert witness that you've had throughout your career?
I don't know if I've got any tentpole cases. I think I think I'm a much better expert witness now than I was, 5 years ago or 10 years ago. I'm not kind of thinking of a eureka moment necessarily where, everything fell into place. I think it's more my improvements. I think it's more incremental, important, with each passing year, I work on more and different types of engagements. I learn more and more, so, again, lawyers, some lawyers I've worked with are really friggin' smart lawyers. And it's I'm like, wow. I learn a lot about how litigation works from these very, very smart lawyers. And I also learn a lot about, well, this is a person who's at the very top of their career and what they're doing. And it inspires me to try to kind of, even though I'm not a lawyer, I'm in a different line of business, but still this person is just very impressive, knows what they're talking about. And I can see why they're a very successful lawyer. Right. And I think, if I can kind of channel that more in what I do in being an expert witness, so, maybe one day I'll end up, in the same position. So, yeah.
Before we wrap up, do you have any final advice for expert witnesses or attorneys that are working with experts?
Okay, if you're an attorney and if you're working with an expert, don't micromanage the expert. And if you're a plaintiff side attorney, try to maintain arm's length between the plaintiff and the expert. And if you're an expert starting out, particularly if you're going it alone with your own business, just take billing seriously. Try to give the client or the retaining attorney a very good sense of what they think what you think the billing is going to end up being. And another thing is, if you can find good junior staff, as I mentioned before, I've got these students, super smart guys who work for me on a contract basis. They're a godsend. So if you can find people like that, just find them and treat them well so that you can keep them for a year or two. Although I had this one guy, he's about to graduate with an MBA, and so he'll probably be off doing a real job, and he won't want to work for me anymore. But I'm gonna until the very last day that he's going to be off doing that, I'm going to try to get him to help me because he's fantastic.
Outstanding and sage advice. Dr. Cross, thank you so much for joining me here today.
It's been a pleasure, Noah.
And thank you, as always, to our listeners for joining us for another edition of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.